I'm about to sign some very important executive orders of our new administration.
On his first day in office, US President Donald Trump issued an executive order which was intended to end birthright citizenship. This has been a foundational principle which grants US citizenship to all children who are born on US soil. That right has been enshrined in the US Constitution for more than 150 years. Lawsuits challenging this directive were swiftly filed. There were judges in several states who issued nationwide injunctions to stop the order from going into effect. But last week, the Supreme Court of the United States sided largely with the Trump administration. It rejected the nationwide injunctions that had been blocking the Trump order. This now effectively clears the way for the end of birthright citizenship to be applied, at least in a temporary fashion, in a majority of the states. In at least half of all American states, there will be no more birthright citizenship if a national order from the Supreme Court doesn't come into effect in the next 30 days. That does leave a lot of questions in its wake. Will babies who are born to undocumented immigrants, in some of these states at least, be entitled to citizenship and in some others not be entitled to citizenship? Can children who are born to such undocumented workers in states where the order is yet to take effect, can they be deported? Will a new court challenge start the argument all over again? So there's a lot of uncertainty, and here are some possible answers to those questions. So the first big question is, do the restrictions on birthright citizenship take immediate effect? The answer is no. Immigrant rights groups across 22 states, which are all ruled by Democratic governors, had sued against the birthright citizenship order. 3 federal district courts had vacated this policy, and there were injunctions that were ordered nationwide. Amongst these states were Arizona, California, Maryland, and New York. Most of these, like I said, are Democrat-run states. Legal challenges in those states are now likely to try again. But a larger number of states, 28 of those states, had not challenged this order in various courts. Many of these states, of the 28, like Arkansas, Mississippi, Texas, and North Dakota, they happen to be Republican-run states. So, technically, this order can come into effect in these Republican states. But the Supreme Court has put in place a 30-day delaying period before the order can take effect. That 30-day window basically allows time for any new legal challenges against the birthright citizenship orders issued by President Trump.
Thanks to this decision, we can now promptly file to proceed with numerous policies that have been wrongly enjoined on a nationwide basis. And some of the cases we're talking about would be ending birthright citizenship, which now comes to the fore. That was meant for the babies of slaves. It wasn't meant for people trying to scam the system and come into the country on a vacation. This was, in fact, it was the same date, the exact same date, the end of the Civil War. It was meant for the babies of slaves, and it's so clean and so obvious. But this lets us go there and finally win that case, because hundreds of thousands of people are pouring into our country under birthright citizenship, and it wasn't meant for that reason.
Now the question is, what happens next to all these legal challenges against Trump's order? Well, the Supreme Court has rejected the ability of a single federal judge to block the enforcement of this order nationwide. The justices did carve out other legal pathways for those who are trying to challenge the denial of birthright citizenship. One of those possible legal avenues could be what is called a class action lawsuit. In a class action lawsuit, a group of plaintiffs are certified to represent a large class of people who are equally affected and who have the legal standing to sue together. But before that, before a class action lawsuit can be filed, a judge must approve it as class-worthy. So the 30-day delay basically imposed by the Supreme Court of the United States gives lawyers time for legal challenges. One of the most famous class action lawsuits in the US ended racial segregation in classrooms. The court's decision means that unless a court, a federal judge, certifies a class action within the next 30 days, then the Trump administration can start to implement the repealing of birthright citizenship. Then there is the question of whether there will be stateless babies born in America. Babies who are born to immigrants who do not have full legal status, particularly in the 28 Republican-run states where there was no legal challenge, they could legally and technically be deprived of U.S. citizenship. If Trump's order goes into effect a month from now without any nationwide striking down of that order, then the newborns in these states could be vulnerable to deportation. They could also be declared as stateless because they are neither U.S. citizens nor citizens of the country of origin of their parents. Some babies would be able to acquire the foreign citizenship of their parent country, the country of origin of their parents, if that country allows. However, if they were born to parents from countries that do not recognize derivative citizenship through a parent or through both parents, then those babies could end up stateless. India, for example, does not allow for a person to hold two citizenships or two passports. You cannot be an Indian passport holder or Indian citizen and a US passport holder or US citizen. It would also be a hassle for Indian parents who are living and working in the US, who have had babies there, to travel back to India or even to go to Indian missions in the United States in order to acquire citizenship for their newborn babies. If a baby is born in a state that supports the Trump order in opposing birthright citizenship, like Texas, for example, the child would not be eligible to apply for a U.S. passport or get benefits as a U.S. citizen. Last week, the Attorney General of the United States, Pam Bondi, evaded questions about who would exactly be responsible for vetting the citizenship of newborn babies. Now, there is a big question mark as to whether medical professionals, doctors, gynecologists who undertake the pregnancy and the birth of children, would they be the verifying authorities for the citizenship of these newborn babies?
Who would be tasked with actually vetting citizenship? And how, would this be a situation where you have nurses and doctors checking for citizenship of parents, or?
This is all pending litigation. It's going to be decided in October by the Supreme Court, and we'll discuss that after the litigation.
Several legal scholars have also said that the children's ability to remain in the U.S. would most likely be linked to the immigration status of their parents. So, for example, if a child was born to two parents who are both undocumented, then the U.S. government could deport all three of them. What happens then to babies who are born to parents who are on temporary visas like the H-1B or the F-1 and F-2, the student visas? Now, under Trump's order, children of people who are on visas in the U.S. either to study or work for a temporary period of time, they would also be ineligible for automatic citizenship. For example, babies who are born to a parent or both parents who are on a temporary work visa, like the skilled H-1B visa program, they would be deprived of their babies being able to apply for U.S. citizenship. That would make it extremely difficult for Indian techies who are on H-1B visas to have their children in the United States. It is possible that these babies would inherit the same temporary legal status as temporary foreign workers, just like the legal status that their parents have. That would make it complicated, in fact, even impossible, some would say, to obtain benefits or passport of a U.S. citizen. But one silver lining there is that they would be unlikely to be deported because they have the same legal status like their parents. But it would also mean that the parents would then have to go through the cumbersome process of obtaining foreign citizenship, the citizenship of the country of their origin. Sometimes they may have to travel thousands of miles back to their home country with a newborn, or go to the mission, the embassy or the consulate of that particular country, to apply for citizenship, which in the best of cases can be a cumbersome process. Imagine doing that with a newborn baby.
Network 18 decimates Times Internet with over 6 times more unique users on social media. Network 18, the undisputed leader of news networks.